to order. Madam Clerk, please call the roll.
Council Member Diegues.
Here.
Council Member Fernandez is absent. He had a family emergency. Council Member Rodriguez. Oh, I'm sorry, Vice Mayor
Present.
Rodriguez.
That's fine.
Council Member Ruano.
Present.
Council Member Alvarez is absent, and Vice Mayor Collazo. I'm so sorry. I am so sorry. I'm reading from the wrong roll call. Council Member Collazo.
Present.
Mayor Sid.
Present.
Mayor, you have quorum.
Thank you, Madam Clerk. Let's all rise for the prayer led by Raul Lopez, one of our town attorneys. Remain standing for the prayer led by the pledge led by Lorenzo Cobiella.
I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all.
Thank you. You may be seated. Order of business, deferrals, additions, deletions. Any deferrals, additions, deletions? Any motions to approve the order of business?
Move the order of business. Second.
All those in favor?
Aye.
Any opposed? Seeing none, the motion passes. We're on to public comments. Madam Clerk.
It's been a while. Martha Mendez, 7,000 Glen Eagle Drive. I want to thank you for calling this meeting. What I would like very much, you've been to meetings with the mayor of Hialeah. You've been in executive sessions with the lawyers. We know nothing. We don't know what's happening. If you would be kind enough to allow, if after your discussion you do public speaking, if we have any questions. That's all because I don't know where you're going, what's being said, what you know. I don't know anything. Thank you.
Thank you, Mita.
Bonnie Cintron, 14770 Lewis Road. Thank you. I do want to thank you, the ones who were downtown and speaking at the commissioners' meeting. It just does my heart good to see you fighting. I'm here because my son couldn't come, and he asked me to come and remind everyone of the sketches that he sent a while back, and he said they all got copies, Mom. And he had also written and went back and forth with FDOT, and they had said that his plan was something that they could do. They didn't commit to it. They just said they could if both mayors agreed. But what Derek was telling me to please convey was that his plan is not just for ramps on 154th, but it involves both 154th and 170th. I know that would be a big expense, but then you have to remember that FDOT, if they were to open these bridges, would have to construct new bridges because we know the structure is not safe. And who would be responsible if that bridge collapses and kills people that are on it? I mean, I don't know if it would be the towns or the commission who that approved the opening. I don't know who would be responsible, but it's a good possibility that it could not withstand traffic, so they'd probably have to build 2 new bridges anyway, which is a big expense. And with these ramps, Derek said that he said, Mom, it helps the people on the west side because they could come onto I-75 and go north to 170th and get off to the school that they need to go to there. That was one of the parents that complained that it took him almost an hour to get his child to the school for autistic children. So that was Derek's idea. He said they get on and they go north and get off right away. That still prevents a lot of through traffic, which is all bottlenecked. It helps somewhat. It's not going to be a wonderful thing because the ones that want to access the Palmetto are always going, that is tied up sometimes up to Miramar Parkway, the I-75, waiting to get on to the Palmetto. So there's always going to be congestion there. But this will still prevent those people on the west who want to come through here to get on to the Palmetto, that they think that's going to be their way to do it. At least it alleviates some of that. So he said, just remind everybody that it works best if both bridges are not open through traffic, but that have ramps. So that was my message. Thanks.
Thank you, Bonnie. And it was good to see you over there at the County Commission meeting.
Anyone else for public comment? Virtually, I see we have one participant. If you're virtually and you want to participate in public comments, please just state your name and address for the record, and welcome to the meeting. Mayor, I don't think we have any more public comments.
Thank you, Madam Clerk. We're moving on to, actually, the only thing that we have left in the agenda, new business. I'll pass it on to our Town Attorney, Raul Gustesi, for the first item, which is item 14A.
He went to go get copies of the resolution. We're ready, and I need the clicker, and I need the presentation. And we're ready. All right, where's the clicker? All right, all right. Thank you. Hold on. Yeah. Hello? Okay. All right. And I think Ms. Mendez had a good point. There has been a lot going on, and I think obviously you know it. There's been 2 executive sessions. I've spoken to you, exchanged emails, everything else. But I think it's important, not only for our residents, but hopefully for the residents of Hialeah and unincorporated Miami-Dade County, that they see some of this as well. And we've got to go and start back in order for them to understand how we got to where we are. Miami Lakes incorporates in 2000. In 2003, the county wants Miami Lakes to take control of its roads. Wants us to plan them, design them, construct them, but most important, the part they cared about most, obviously, was maintain them, repair them. Since 2003, Miami Lakes has been doing exactly what it had to do under the agreement. Under the agreement, we call it the Road Transfer Agreement, or the RTA, Miami Lakes and Miami-Dade County entered into an agreement that says in any number of places, the title to the roads is transferred to Miami Lakes. The duty and the obligation to plan, design, and construct those roads is on Miami Lakes. We have spent, the town manager can tell you better, how many hundreds, if not millions of dollars maintaining those roads. We've gotten concessions from developers to maintain the roads, especially in NAR. We comply with the agreement. No one has ever said that Miami Lakes has violated one word of that agreement. Not one. Thereafter, Miami Lakes, starts having huge concerns, legitimate, justified concerns, which have been borne out and which were true about the amount of overdevelopment on the other side of I-75. We told Miami-Dade County, we told the city of Hialeah, you are developing way, way, way too much. This is unacceptable. What you're doing to the northwest corner of Miami-Dade is not acceptable. 13 units to the acre, thousands of homes. You think there's a lot of homes out there now? Wait till you see how many are on deck. It's more than what's there now. Miami Lakes took issue with what was going on. When Miami-Dade County went to amend its CDMP, its Comprehensive Development Master Plan, it was not, there were many objections to it, including Miami Lakes. We intervened into an administrative proceeding. It's a state administrative proceeding. It's a legal proceeding, but it's not in the courts. It's in the administrative courts. Miami Lakes intervenes in that proceeding. As part of intervening in that proceeding, that held up the whole process. Our huge and our biggest concern was traffic coming from the other side, flooding Miami Lakes' streets, while Hialeah and the county do not adequately plan their streets, their development, and the ones who are going to pay the price, besides the poor residents who don't realize what's going on over there, are our residents over here. As a result, and in order to resolve that lawsuit, we entered into a second interlocal agreement just with the city of Hialeah. We agreed with the city of Hialeah that 154th Street, we're litigating over 170th, but now I've moved to 154th. We agreed that 154th Street would not be developed ever. They're not even supposed to be advocating for its opening, which they have completely blown out that provision of the agreement. Let's not call it any different than what it is. They are violating the interlocal agreement just by advocating for the opening of 154th Street. It is flagrant. They're all doing it. We can go to any number of statements. We can go to any number of television programs, council meetings, news stories, publications, whatever you want to call it. They're violating the agreement. We haven't filed suit. We haven't done anything about it. We're not okay with it. We've complained about it, but we're not okay with it. They're not even supposed to allow their land to be used for it. They're not supposed to grant the land. They're not supposed to give a permit. They're not supposed to do anything as far as 154th Street is concerned. So there are two agreements already in place. This isn't Miami Lakes just complaining, trying to do something about traffic, trying to get in the way of development. No, we have specific written agreements that say what they're trying to do cannot be done. The portrayal of Miami Lakes as being difficult or wanting to stand in the way or being arrogant is just not true. They're not getting the whole story. There is an agreement signed by Mayor Bovo, who then was president of their council. He signed that agreement. That agreement was passed by their council. It was negotiated by our council, our lawyers, and it was negotiated by their lawyers and their council. 154th Street should not even be a topic of discussion. There is a 100% agreement binding on both of our municipalities on that. On 170th Street, there is an agreement binding between Miami Lakes and Miami-Dade County that is clear. It's unambiguous. It says Miami Lakes plans, designs, and constructs its roads. That's it. Nobody else is supposed to be doing that. As a result, when we heard what they were trying to do, when I heard what the county commission was trying to do, which is pass a resolution to open up 170th Street, we tried to do the dispute resolution process. I have met with the lawyers, I don't know how many times, prior to filing the lawsuit. Come on, guys, this is not okay. Let's come to a solution. Let's try and resolve this. And remember, you're going to hear a theme throughout my presentation of me saying, come on, guys, let's try and resolve it. There isn't anybody who has tried to resolve this more than the town of Miami Lakes, through my firm, through the mayor, and through everyone else up here. We have communicated in every single way we can with the county and with the city of Hialeah to try and resolve this. There is nothing more we can do. It is our way or the highway, and that's what we constantly get. Yes, well, let's talk. Yeah, you're right, we should talk. But in the end, there isn't a single compromise. Today, there has not been a single compromise from them other than we're opening up these bridges, whether you like it or not. And it's constantly ending up further and further and further, as you'll see. Northwest 170th, the description of Northwest 170th Street is important, and where it lies is important. It appears, and I haven't sat down with the surveyor in several years, that about 2/3 of 170th Street is in Miami Lakes. The surveyor will have to explain this at some point during the trial. I think the description, the legal description for Miami Lakes is to the middle of 170th Street, wherever that is. The thing is, where the actual road is platted and where it may have been built is not lined up. But we own at least half, and we probably own at least 2/3 of the road itself. This is the road transfer agreement. The county's position, Hialeah's position, Lennar's position, Downright's position has been essentially that the county's charter says something about traffic engineering. In other words, and the agreement mentions traffic engineering. When you look up the definitions of traffic engineering, that is essentially, and from what I've observed in practice as well throughout the county, they control the flow of traffic, speed limits, stop signs. If you close a street, not opening, close a street. When we closed the streets in Royal Oaks, we had to go to the county to get permission. When we wanted a stoplight on 162nd, we had to get permission from the county. Speed limits, you're supposed to get permission from the county. Crosswalks, things like that. School zones, those types of things, that's traffic engineering. But it's not construction. None of the statutes in the county code mention the definition of traffic engineering, including the word construct. Essentially, that has been their position. The other position that the county has taken is, well, we have the right to close roads. And that's fine. But this road's not open. So how can you close it? And if you meant in the ordinances and in the charter that you retain the right not just to close roads, but to open them, you had to say it. All of this was in our brief. All of this was argued at the lower court level. This is in the road transfer agreement. Whereas the county and the town are desirous of transferring the underlying title That means we own it. And responsibility for the planning, design, construction, improvement, and maintenance for the road segments from the county to the town. Another issue in the litigation was, well, the road doesn't exist. That section of the road doesn't exist, so it's not up to you to plan and design and construct the road. Well, it says improvement too. By adding to the road, you're improving it. Once again, the responsibility for the operation, maintenance, planning, design, and construction of the road segments and of any future improvements thereto be transferred to the town. Again, paragraph 2 within the body of the agreement, except for 87th, for a certain section of 87th, for a certain section of 67th, and I think 57th is another one. Here's where the only right that they maintain in the agreement, paragraph 3, the right and responsibility to regulate traffic and determine appropriate measures for and provide traffic control devices such as traffic signals, signs, pavement markings, including road closures or traffic calming devices, is not transferred to the town. The county retains traffic jurisdiction over traffic engineering matters. When you go to the definition of traffic engineering, you'll never see the word construct. More of the same in the road transfer agreement. This is the interlocal agreement which we talked about. Hialeah promises to the town that they wouldn't open it. Hialeah actually requested that the county close 154th at one point. It's signed by the parties. And then I was trying to engage in what's called the dispute resolution process. The dispute resolution process is for when two governments have issues between them. Instead of literally flying off the handle and going to court, you've got to try and resolve it. And there's a procedure. We meet at the staff level, then we mediate, then the two bodies meet. There's a whole, and it may not necessarily be in that order, but there's a whole host of issues. So I tried to implement that procedure. When we're literally commencing that procedure, they don't care. They keep on with the construction. They keep coming with the construction over on the other side of I-75, making improvements to the bridge. And then all of a sudden, they decide that they're going to start doing some, I don't know exactly what they were digging for, but they were doing some deep digging on our side of the road in our part of the town. Town manager called the police. They all went out there, and essentially, they stopped digging. They actually put it back and said, okay, fine.
Raul, I have a
Yes,
question.
sure.
And I don't know, Manny, is it okay to ask questions this time, or do you want him to finish? Okay. Well, thank you, and I guess through the mayor. During the proceedings of dispute resolution or any of these opportunities that you've had to negotiate with the other parties, have we offered alternatives other than the immediate opening of the bridges?
Yes and no. It depends. I'll get to that, but yes, we have tried to negotiate. Well, anything short of opening 170th is a non-starter for them. They will not even discuss it. They will not sit down, go to court, do whatever you got to do. They will not have a discussion on anything that doesn't involve opening 170th immediately.
So any alternative that's not the immediate opening of the bridge is a non-starter for them at all
Yes.
the negotiations that you've been to,
Every single time.
including the design submitted by Derek Cintrone, including all the alternatives that are outlined in the studies. That
They
has
will
always
not-
been a hard line in the sand.
That is a hard, fast, no, non-starter. There's nothing else to talk about. My understanding is the manager tried to talk to FDOT about those designs, and I think those designs are also
The
a
MPO
non-starter.
is studying those designs. Commissioner Garcia yesterday, was it yesterday in the county commission? He stated that the MPO, and correct me if I'm wrong, Councilwoman, but I don't know if you guys heard that, but that the MPO is studying the on-ramps, the slips to I-75. So
That's news to me.
the issue with that is that while they can study it, it's not a state highway, right? So it's a federal highway. It's a longer process. But the MPO has already moved forward with studying those on-ramps to I-75, which the initial study of those on-ramps to I-75 said that there wasn't a need for on-ramps. The initial one, many years ago. Fast forward now, obviously things changed, so that's why they're studying the issue again. Commissioner Garcia put that on the record yesterday.
Thank you, and again, Mayor, thank you for adding that, the additional. I recall when we were in Tallahassee and met with FDOT, they had never given us a clear, definitive no either, right? Nobody has ever told us that's an absolute no. And I think that's really, and I'll bring that up a little bit further down in the meeting, because I think that's a very important point, right? And a very important point that we have always strived to have as part of the conversation, alternatives, right? There is no need to immediately open up 170th if there are other options, right? And again, I use colorful words that I've been associated with for many, many years, but right, looking at those options has always been front and center. But just to be clear, every time that you have tried to discuss options with them, they have said absolutely no, under no circumstances.
Absolutely no. It is a no, in no uncertain terms. It's been very difficult to negotiate to a certain extent. Things have become a little easier now, but I'll get to that. So while I'm trying to negotiate, while I'm trying to come to a resolution, I don't know if the left hand doesn't know what the right hand is doing, but all of a sudden, the next thing I know, I'm on vacation and I'm having to deal with, wait a minute, these people are now digging on Miami Lake side without so much as even a heads up. They stopped, they covered the hole and everything else, but because of that, and because of, there are provisions within the statute that say, hey, if you determine that there's an immediate need to proceed with litigation, instead of going through the dispute resolution process, then by more than 3/4 of you, 1, 2, 3, 4, 5. There's only 5 of you here. Great. Okay? Because we need 6, by the way. I'll finish my presentation, but it's got to be more than 3/4. They can vote, but we need one. Wait, no, there's 5 of you here. I need one more.
Well, are they allowed to vote?
They can vote by phone,
Okay.
by
They
electronic
don't
means.
have a quorum. Okay. That's what
Yeah.
I wanted to confirm.
All right. Yeah. If not, we'll just continue it to Tuesday, but I would really like to do it tonight if possible.
Ro, I think what you're going to ask them to do is amend what's already in place, and that, I think, is what requires 3/4, right?
Well, I'm
The-
going to ask
the-
them,
They've already taken the action that I think you're talking about. I think what you're looking for is
Well-
amending what you've already done just to add a different complaint.
I'll explain it.
Yeah.
I'll explain it. So, I have to, we started with litigation. As I expected, a motion to dismiss was filed. We argued it. It took a while to get to the motion to dismiss. 2 or 3 judges recused themselves. COVID hit. A bunch of reasons. It took 9 months. Interestingly, one of the arguments that was made by the city of Hialeah was that we waited too long. Well, I think we're on either our 3rd or 4th judge. That argument didn't fly, of course. Unfortunately, the trial judge dismissed the case with prejudice. Dismissing the case with prejudice means that you can't refile it. And he also ruled that we had to include the Florida Department of Transportation as a defendant, and we didn't do that. I didn't think we needed to do that. Fast forward, we do all the briefing, we do all of the, everything that needs to be done on appeal. While on appeal, we held a mediation conference. Lennar refused to attend, downright didn't want to attend. The county, Hialeah, and Miami Lakes were the ones who attended the mediation conference. The mediation conference lasted probably the better part of 2 days, from what I recall. There were a ton of negotiations and a ton of calls leading up to the mediation conference. There were times when I thought, goodness, I think we're going to have a deal. It would fall apart. I would write versions of the agreement. I'd send them over. They'd fall into a black hole. But that's not what we talked about, is what I'd hear. I say, okay, fine. Redline it like I do in every single case, every transaction, every litigation. We prepare a settlement agreement. The other side redlines it and sends it back. Would rarely happen. It was like pulling teeth. On and on with the same process. We finally decide to end the mediation because it's a waste of time and money. We continue to negotiate. As the deadlines for the briefs get closer, we negotiate some more. Once again, I send over some more drafts of agreements along the lines of what we talked about. They fall into a black hole again. Half the time, I don't get a red line back. When I do, it's completely ridiculous, nothing that we'd ever agree to. There's a change in administration in Hialeah. Well, there's a change in administration in Hialeah. We start having some talks. I tell them, the lawyers, guys, that we expect the decision to come forth pretty quickly. If the decision, which I believe will come out in our favor, comes out in our favor, things could change dramatically, because now the landscape is different. The mayor and I, Mayor Bovo, his legal staff, we met. We discussed possible resolutions, different ideas, things like that. I brought them forth to you at the executive session, at the 2 executive sessions that we had after that. We discussed them at length. We sat with some of you who had specific concerns about the agreement and tried to incorporate those into the agreement. We sent them over. Once again, they sit there. They don't come back. I can tell you that the mayor and I, since probably Thursday, have been talking 10 or 15 times a day maybe. The mayor has been doing everything he can to talk to Mayor Bovo, who has been extremely reasonable, by the way. He wants to do a deal. He's not being a hard guy, let's put it that way. He wants to do a deal. He wants to see how there's something that can be done to end just animosity on this issue. I believe he really does want to do that. I believe that Mayor Levine, Cava Levine, wants to see this resolved. I believe that the vast majority of the people on the county commission want to see this resolved. I believe that their legal staff wants to see it resolved. I believe the transportation staff wants to see it resolved. The question is, does the commissioner in the area want to see it resolved? That's the question. That's kind of the holdup. We have done everything in our power to come to an agreement and to convince the appropriate people. Okay. And to convince the appropriate people. The ball's in their court. There's not a whole lot more that I can do. I sent them another draft, I think it was Sunday morning. I have sent, I believe that some in the administration don't know exactly 100% the history. There's discussions on 154th Street. I think some of them were a little surprised that there's an interlocal agreement between the city of Hialeah and us. on 154th Street that it doesn't open. Whereas Hialeah is saying, I want it open, I want it open. But wait, you signed an agreement with Miami Lakes that says you don't want it open. I believe that's come as a surprise to some of them. FDOT has said, my understanding from reading the email, that they're not interested in shoving the bridges down our throats. In other words, compelling us to do it. First of all, I don't think they can do it legally because it's not part of the state road system, and those roads have been transferred to us. So I think it's very, very difficult for FDOT to compel us to open those bridges. I just don't know that anybody's telling the residents of unincorporated Miami-Dade County and Hialeah of the legal impediments that they face. I just don't know that that's happening. I haven't seen anybody doing it. I haven't seen anybody sitting up in front of their council doing something like this, meeting in executive sessions to tell you what the issues are. I just don't think that's going on, but that's my perception. The ball's in their court. I've tried. That's the only thing I can do. I don't think FDOT will open it up. We have two agreements between us that say they don't open up, and planning, design, and construction is ours. So, what's the latest salvo? The county, knowing the problems they have, because I got the feeling someone within the county's legal department, because they're good lawyers. They're personable guys. I have nothing bad to say about them. They're colleagues. They're guys that I can talk to, pick up the phone. We have each other's cell phones. When we need to talk to each other, we talk. It's civil. It's not bitter in that sense, in the least. They're professionals. But the county, what they then did, taking a step back, we filed a 3-count complaint for injunctions, and not only for from breaching the contract, but from doing it in the future. I'm summarizing. The 3rd District Court of Appeal did not say, Miami Lakes, you win. Not even close did they say it. In fact, they cautioned against it, specifically in their opinion. But it's very interesting what they did say. They said that Miami Lakes states a cause of action. What that means is we allege that there is a road transfer agreement, and we allege that we're responsible for planning, design, and construction, including improvements to the street. By reversing on the issue of the motion to dismiss, and by saying specifically that Miami Lakes states a cause of action, that means that a logical interpretation of that we are bringing forth, a logical interpretation of the contract. Because when you are looking at a motion to dismiss, especially in a contract case, that's what's called a matter for the court, as opposed to who ran the red light, what did a pedestrian see? Those types of things, those are questions of fact. Those are for trials, for a jury. But this is a question of law for the judge, for the appellate panel to review it and say, as a matter of law, have they stated what's necessary for a cause of action? So that means if you read that agreement and we're stating how it's to be interpreted as a matter of law, that is I guess I'm trying to explain in layman's terms. That is a logical way of reviewing that agreement. It doesn't mean we win, but when you're on the other side of that opinion, you're very, very concerned, because all of the defenses that they threw at us to try and throw the case out, in essence, pretty much the appellate court has said they don't apply. That's not 100%, but it's pretty darn close. And you've got to be concerned legally from their end. So we get to closer as to where we are today. Knowing that this is about to come, because they read all our briefs, these lawyers are very smart. They are advising Interior, just like I do with you. They're advising their people of what they think or how they think the litigation's going to come out. So what does the county do? Oh no, I'm going to end this. Now they enacted an ordinance in October that essentially says we're taking away all permitting for any roads from all municipalities. There's only one person that can issue a permit for a road in Miami-Dade County, and that's Miami-Dade County. That's it. We're done with this. Well, the problem with that is there's an agreement that says that we do it. So you can't sit there, in my humble opinion, legislate yourself out of a binding agreement. You just can't do that. Not only does that go into our traditional notions of fair play and justice, like you see in some of the case law, it's just wrong. On top of that, we believe under the state statutes and everything else, once you transfer a road by agreement and everything else, that's it. The road's transferred by state statute. And in order to transfer responsibilities over that road back, there has to be another agreement. Okay, so here's the ordinance. And I'm actually reading it to you a little backwards because of the quirky way in which it was written. The ordinance says that municipalities are prohibited from charging any fees, imposing any requirements, including but not limited to maintenance of traffic requirements, or requiring that any permit be obtained for any construction work, including any public works, on any road that is subject to paragraph B2 above. So B2 above, it's unlawful for any person or corporation, partnership, agency, anybody and everybody, without first obtaining a permit from the department to do any construction work or anything like that, or move. They want it all. And this is what they did in October of 2021. So their attack now is two-pronged. Number one, to try and get FDOT to issue permits and compel opening of the bridge. And the second attack is to try and use that statute to tell Lennar and Downright, hey, here's a permit, go construct. The reason that I asked you to call this meeting, and now I'm going to the manager's issue or question, is because we got authority to file suit because of the trespass and everything else. I believe I can probably continue on with the litigation and amend my lawsuit. When I say my lawsuit, the lawsuit. Amend the lawsuit and include a cause of action saying, hey, not only were they doing this, that, and the other, but now they're going to try and do this to us. I probably have the authority based on the way the resolution was written before. But the last thing I want to do is give my opponents another procedural line of attack and say, wait, you didn't get around you don't have dispute resolution authority and didn't comply with the statute to bring this, because we may bring it as a separate cause of action, or we may just amend one of the counts. I'd like to bring it as a separate cause of action, but there's a whole host of reasons which gentlemen much smarter on this than me. We're in discussions amongst the lawyers in the firm. So I believe that it would be prudent to get authority under the dispute resolution procedures, in other words, to bypass them and try and have this ordinance not apply to Miami Lakes, especially Northwest 170th Street. That's a long way of explaining why I need the authority and where we are and how we got where we are. If I'm not mistaken, today is the 15th day? Tomorrow's the 15th day? Okay. The way I understand the rules of appellate procedure, once an appellate court makes its decision, the mandate, meaning they issued their opinion, but now the mandate, the part where they tell the county, the circuit court judge what has to be done in accordance with their opinion, issues tomorrow. I believe the reason is because you have 15 days to go and ask to be heard before the entire panel of the Third District Court of Appeal. I doubt they'll do that, but if they do, then they do. That's not something that I'm in control of, where they'd ask for a motion for a hearing before I think they call it en banc. If not, then the mandate should be issued in a few days. My concern is, and my understanding is, we've had call it a gentleman's agreement with the county that they wouldn't proceed on 170th until the litigation was over. That's why, it moved pretty quickly. They gave me a hard time about getting extensions of time and everything else. But I think we've been told we're not, because of whatever procedurally is happening within the county, that may not be the case. So we're going to have to move quickly because I'm concerned about that. The statute or the ordinance says that they have to advise the town when they're going to issue a permit and tell the town, hey, we have 30 days for you to give us input. We cannot, under that ordinance, impede the issuing of the permit, but we are able to send comments. Needless to say, we sent the comments. We objected to it both on legal grounds and we objected to it on technical grounds. We don't believe that these plans and designs meet technical requirements. Not on the bridge. I'm not saying the bridge is going to fall down or anything like that. We're just talking about the surface areas of the road and things like that. Our engineering department knows those technical requirements better than I do. So that's kind of the long history of why I need 6 of you to vote to bypass the dispute resolution procedures and go straight to the litigation. I probably don't need it, but in an abundance of caution, I would prefer it. Any questions, anything?
Yes, and thank you so much, Mr. Gastesi. I have a question regarding some comments that were made at the Board of County Commissioners meeting. Chairman Diaz specifically said that he would back off on 154 and allow the 2 mayors to come to an agreement unless the county was sued again. That if the town of Miami Lakes was threatening to sue the county again, I want to quote him because I don't want to misspeak. He says, if we are sued on 170th again, all bets are off. I don't know exactly what he meant by that. It is definitely a threatening statement, but I don't know what he meant exactly by that. But he is under the impression that we are going to sue him, the county, not him individually, that we are going to sue Miami-Dade County again. This is, in fact, the same lawsuit that we filed initially, correct?
Yeah. Hello? What we would be, there's 2 things that have to be done. As a result of the county's and Hialeah's position and Lennar's and Downright's position, as a result of them stating that we need to include FDOT as because they are, quote, an indispensable party. I disagree with it, but more important yet, the Third District Court of Appeals disagrees with me. So, and they agreed with the trial judge on that issue. So as a result of their insistence, and the courts agreed with them, I will be amending the lawsuit to include the Florida Department of Transportation as a defendant in the case. I believe eventually they will get dismissed, and they'll file the appropriate pleadings to get themselves dismissed. So Our lawsuit will go on 1/70th, but I am amending the lawsuit to include a cause of action or or additional allegations to invalidate the application of that ordinance as far as Northwest 170th Street is concerned.
Okay, I just wanted to make it clear that we are not suing them again. We are not engaging in a new lawsuit. This is the same lawsuit that was, that we appealed to be heard, and it will be heard.
It will have the same case number. How's that?
Okay, I just wanted to make it very clear because I was disheartened by the comments made. The comments were that 170th must open right away, that Miami Lakes must give permits for that road to open right away, and that basically we have 15 days to figure that out, or Chairman Diaz will proceed with his resolution on Northwest 154th Street.
Okay. A couple of comments on that. They have my number. They know where I am. I have sent them any number of drafts. And when I mean any number of drafts, I'm waiting for them to respond. I will listen. I have made myself available, even this past weekend, except for between 7:30 and 11:30 when I play golf. But other than that, I made myself available the entire weekend. The mayor worked his butt off the entire weekend trying to get something done.
I understand, but when
Yeah.
you sit through these meetings and you listen to the comments and you hear things that are not true, you hear things that are misstated and misguided and just false in nature, I just want to make it clear, since we're having this meeting this evening, that is not what we are doing. I want to make it clear to our residents that we are not suing again. I don't want it to seem like we've been threatened by the county and we are suing again, on top of that threat. I think that maybe the chairman is misinformed.
I really want whoever hears or listens to this to encourage people to listen to this. Miami Lakes is not arrogant. It's not like we want people from Hialeah not here. We are concerned about the amount of development that's going on over there. I went in front of
But Raul, I think Councilwoman Ron, I think we got a reporter back there, so hopefully listening to your comments and following along, right? So there'll be an article hopefully in the Laker with the correct verbiage.
I went in front of, I forgot what the organization's called, the MPO or something, I forgot what it is, with one of the developments that was being modified. We went out there, the manager, our planner, the plan, the way it was being done, it was David Martin's development. David Martin's a pretty responsible developer, but he is a developer. He wanted to modify it the way it was. He could not build what was there because it wasn't something that would work. So he wanted to change it. That was a perfect opportunity for Miami-Dade County and for Hialeah to say, wait a minute, we'll modify it, but less residential, less impact on traffic. I went in front of that council. One representative from each member of the commission. I got 0 votes, not one. I went back on the item when it got back in front of the Board of County Commissioners. I told them, now's your time. Stop blaming past commissions. Stop blaming past planners. Stop blaming past developers. You now have this opportunity. It's in front of you. You know how many votes I got? 0. The residents on that side need to listen to Miami Lakes and what we're saying. We're talking about, and what we've said is, there are things that are being planned. If you go to the FDOT's website, you look, we paid $700,000 for a study and for plans to create Texas turn lanes or U-turn lanes, or whatever they're called, underpasses. We paid for that. There is a beautiful layout, video depiction of this thing on FDOT's website. We're saying, make those improvements. Make an improvement on 87th Avenue for people to get on and off, onto the Gratney. Make an improvement on 67th Avenue to get on and off. It'll alleviate traffic. Make those improvements. You can open 170th, but make those improvements.
So at the meeting yesterday, I brought up those exact points, and I asked the commission to look into all of these developments that have been built and will be built, to look into them and find out how they are, how they have concurrency, how they're being, planned, how they're being approved. That all falls on deaf ears. Every single time. That is an argument that they're not willing to listen to. So at this juncture, right, where they have decided what they've decided, and we're more than likely going to move forward with this, what will the repercussions be? Because I know full well that Commissioner Diaz will say, I told you not to sue me. You sued me anyway. I don't know if anyone's had the opportunity to watch the video, but you should, so you can hear his language and what it is that he says. He's going to consider this another lawsuit.
Well,
and he's going to say, I told you not to do it, and you did it, and that's going to be his truth.
Well, the Secretary of Transportation has told us that she will not get involved in the opening of the bridges on 154th and 170th. They don't believe it's a part of the state road system, so they're not going to get involved in that. So his resolution to go before, to get FDOT to open that up could very well fall on deaf ears. If that statute falls apart on them, then we go back to the litigation and where we are. That starts to become very precarious for the people on the other side of that bridge, because they could very well see themselves with 170th not opening for a decade or more. Forget 154th. Neither one of the two opening for a decade or more until they make those improvements.
Well, these road transfer agreements are made. Municipalities put millions of dollars into the maintenance of these roads. You can't just shut it off when you want. The county can't just say, okay, now that you've made all these improvements and maintained these roads, now the agreement isn't valid anymore because we choose for it not to be. We either have agreements or we don't.
Those residents need to talk to their representatives and put the pressure on them. Yes, sir.
No, I just want to jump in just because, and I apologize if I may come across as being a little rude. I could care less what the chair has to say. He's going to do whatever he's going to do. I'm going to do whatever I got to do. This is not a new lawsuit. If he can't understand it, that's his problem,
See,
not
I
mine.
couldn't say that.
Doesn't matter. The point is, I got to go soon myself. I still have to keep working. And, we already know what the issues are. We have communicated it ad nauseum to the commissioners, to Hialeah, to everyone else and their mother. So that is why I think we need to continue and move on with this process. And so I am prepared to move to go ahead and waive conflict resolution procedures as to Northwest 170th Street Bridge.
Second. Any further discussion on this motion?
Yes, please get him on the phone.
I just have one question to the attorney.
We need a sixth. Okay. Okay. I'm sorry.
No, you're good.
Councilman Collazo, then
you-
the vice mayor, and then Lorenzo, please ensure that Councilman Alvarez is talking to the clerk to ensure that he understands exactly what the motion is, please.
I briefly spoke with, Mr. Mayor, I briefly spoke with Councilman Alvarez. He had a prior engagement this evening, so he asked me once I explained to him what we were doing tonight. He asked me once you call the vote for me to call him, and then he will cast his vote.
Councilman Collazo.
Thank you. You repeatedly said that FDOT has no appetite in getting involved with this issue. When we name them party to this issue, do you think their position will change?
Not really, but I'm not going to guarantee it, but I don't think they will. And we don't have a choice, because if we want to go on with a lawsuit, the 3rd District Court of Appeals has determined, as did the trial judge, that they are what's called an indispensable party. So I have to sue them, otherwise the lawsuit will get thrown out.
But you've already explained that to FDOT, and they understand that the reason we have to add them is because we were being told that we need to add them.
I sent them a copy of the Third District Court of Appeals opinion.
Okay.
And I may have sent them the lawsuit as well, but I sent them the Third District Court of Appeals opinion, and they are aware.
Got it.
I would add an exclamation point or somehow if you can communicate it's not by this body, right, or any of the elected officials here. And I'm going to tell you why it's important to me. We have always gone up there to Tallahassee, and we have talked with many secretaries, and we have always advocated on this issue, and they have never told us no, that they're not supportive of our positions or of our alternatives when we've planted them, whether they be the I-75 or other connectivity of issues. So I want to make sure that they understand that this is not necessarily an action that we're taking because we want to, but because the court is obligating
It'll
us
be,
to.
when I do it and I serve it, it will be, reiterated and conveyed again.
Any further discussion on this motion, council? Any further discussion? Seeing none, all those in favor?
Wait, we need
Wait,
we need to
do
get
we have
Carlos
to
on.
Get somebody, yes.
No.
And you need to do a roll call on this, Mr. Mayor.
Got it.
Okay.
Can-
So we need a roll
and
call.
Mr. Attorney, please, if Councilman Alvarez repeat the motion.
Yes. Okay, Carlos, I'm going to put you on speaker. They're going to repeat the motion so you can hear it, and then you can vote. I'm going to put you on speaker now. Is that okay? All right, thank you.
1 second, guys.
Yes.
Okay.
Councilman Alvarez, can you hear us?
Yes, I can.
Thank you. Madam Clerk, please repeat the motion for Councilman Alvarez.
Well, I'll restate it because I think she needed some clarification. It just is simply to go ahead and waive conflict resolution procedures under Florida law as to the Northwest 170th Street Bridge with respect to amending the lawsuit to add a challenge to this ordinance, this county ordinance 2-103.1. Oh, well, Mr. Attorney?
Go ahead. I'm sorry, finish and then.
No, that's where I was going to end it at.
And.
Oh, and to include FDOT in accordance with the Third District Court of Opinion, which is that they are an indispensable party.
Because.
And there was a
Hold on.
there was a second on that.
1 second, I'm sorry.
Yes.
Because you believe as a body that there's an immediate danger to the health, safety, or welfare of the public and that it requires immediate action or that significant legal rights will be compromised if a court proceeding does not take place before the provisions of this act are complied with, no notice or public meeting or other proceeding as provided by law shall be required before such a court proceeding. In other words, that is part of your motion.
I will incorporate that as part of the motion, the required statutory language. I think there's sufficient evidence to show that there is an immediate need for this.
Got it. It's all included, and there's a second. Councilman Alvarez, do you have any questions?
Councilman, do you have any questions?
Yes, no questions, sir.
Thank you. Madam Clerk, please call the roll.
Councilmember Diegues.
Yes.
Councilmember Alvarez.
Yes.
Councilmember Collazo.
Yes.
Councilmember Ruano.
Yes.
Vice Mayor Rodriguez.
Yes.
Mayor Sid.
Yes.
The motion passes.
Thank you, Madam Clerk. We're on to the next item, which is Councilman Collazo's item.
Thank you, Mayor. One of the things that I have noticed, and I think the attorneys kind of mentioned it, through our process, through the executive sessions, we continue to come back to alternatives in different situations or different scenarios that we could consider in lieu of the opening of the bridges. And since we commissioned this traffic study back in 2018, what I've noticed as part of the study that a lot of the scenarios or options may have changed. And what I wanted to do for the benefit of my colleagues that may have not been around when we commissioned this study was to reopen this study and see if we can discuss with Lochner, the firm that engineered, that did the traffic engineering study for us, if there was ways that we can amend the data and see where we stood now. If there were different alternatives, if there were other options, so to speak, that may help us in the negotiation process, looking for alternatives to the opening up of the bridges. So I wanted to make that motion, which was basically to revisit the Lochner study with Lochner and to look at different scenarios that may or may not have been considered during the time that the study was taken, again, as an alternative to the opening of the 170th and 154th bridge.
I'll second the motion.
Got it. Any discussion on this motion? Any discussion on this motion? I just want to make an amendment to coordinate with the MPO on their study that they're doing on the slips to I-75.
I'll second that amendment.
Discussions on the amendment?
One
Discussion on the amendment?
question I had was, would there be any, I think it's great that they would be working together, but I guess my question would be, are they using different assumptions, for example, than our study? Does that have an impact on whether or not?
Every study, to be honest with you, used different assumptions, right? So that's why traffic studies are, I know we coordinated ours with the county, so when we did
When we did ours, we were
initially.
recording. Okay. All right. Yep. Thank you.
But yeah, we don't have to, I mean, just kind of taking in their data that they're using for those on-ramps, whatever it is. But the purpose is to see them happen. So it seems that the majority of the MPO wants to see on-ramps. And I know the majority of the commission talked about that, so. Any further discussion on this? Seeing none. All those in favor of the amendment?
Aye.
Aye.
Any opposed? The motion passes. Back onto the main motion as amended. Any further discussion? Seeing none. All those in favor?
Aye.
Aye.
Any opposed? Seeing none, the motion passes. We're next on to the next item. I'll make a motion to the waiver of item 7.3, the 7.3 of the special rules of order.
Second.
All those in favor?
Aye.
Aye.
Any opposed? Seeing none, the motion passes. We're back onto Councilman Diegues' item.
Thank you, Mr. Mayor. This is very simple. We've done in the past with many other causes. I think this is a worthwhile one. We've all seen the images of what's going on in the Ukraine right now and the slaughter that the Russian dictator Vladimir Putin has been unleashing on his neighbor. And I think it would be a nice show of solidarity. We've already seen that the county has taken some initiative in doing that. I know some other municipalities have done so as well. And I'd like us to be one of them. We already have the blue light. We've used it before for Autism Awareness Month. And so the only lights and the only expense, therefore, that we would have would be to get the yellow lights as well to go along with it. So there's a minimal cost, but that is the extent of what I'm proposing to do, just to do that for 2 weeks from when we get them, to show some solidarity with those that are fighting against the may not be communism in actuality right now, but it certainly is the progeny of the communist state, which is the USSR, given Putin's background. So that is my motion.
Second.
Thank
Any discussion on this, council? Any discussion? Seeing none, all those in favor?
Aye.
Any opposed? Seeing none, the motion passes. Any other motions on the table? Seeing none, this meeting is adjourned.